adjourned and fixed on this second week of April.
With the consent of the side, is the matter on. After 2 weeks, second week of
Second
April?
of April, my lord. I have got the. I will be out.
It will be
of state.
3 weeks, no?
Yes.
After 3 weeks.
Of like
May I please, Your Lord? I mean, this is for matter for listing a IA, my lord.
You'll have to mention before PJ Sirke. Justice
Well,
PJ Sirke.
This court matter, my lord. This is mentioned for IA for correction of a post title of the on 18, my
Hmm?
18.
18.
I'm obliged. May I please, Your Lordship?
Mm.
Lordship, I beg to mention item number 21 on account of my seniors' unavailability today. The other side is present.
Learned Counsel Mr.
M. Sharma on
M.
behalf of Mr.
Sharma.
M. K. Chaudhary.
On behalf of Learned Counsel Mr. M.K. Senior Counsel
Senior
Mr.
Counsel
M.K.
Mr.
Chaudhary,
Chaudhary.
representing the appellate.
Yes.
21.
It's a CRP, Your Lordship. It's a CRP. It's under
Representing the petitioner,
petitioner, Your Lordship.
with the consent of the other side has paid for adjournment. List the matter when?
I'll make it my
After
Bihu vacation, madam.
After Bihu holidays.
There's an interim in our favor, Your Lordship.
Interim order shall remain in force till the next date of listing.
I'm grateful, Your Lordship.
Lordship, if possible, a date may be fixed, madam.
I'm grateful, Your Lordship.
May I please, Your Lord? Lordship, I beg to mention item number 10. It is, we have taken a consent for the other side.
Learned Counsel Mr.
S.A. Bakhtiar.
S.
A. Bakhtiar for Asmin 1.
A. Bakhtiar, representing the item number.
Item number 10. Lordship, I date may 24th of
Your name is not in the cause
Lordship.
list.
My name is not there.
You are on behalf of
Alam.
on behalf of Learned Counsel Mr. N. Alam, representing the respondent, with the consent of the other side has prayed for adjournment. List the matter on date.
24th. Lordship.
24th
24th.
March.
24th. Much.
Lord, I beg to mention item number 14, madam. With the consent of other side, madam, kindly adjourn for the day, madam.
Learned Counsel
K. Uddin.
Mr. K. Uddin, with the consent of the other side,
No, other side. We have
has
taken
prayed for adjournment. List the matter
after 1 week, madam.
after 1 week.
May I please your I beg to mention item number 20 because the conducting counsel could not come for his pre-scheduled engagement. Kindly the matter
Learned Counsel Miss
Atanu Saikia,
A. Soikia. No. Learned
My
Counsel
name-
Miss, your name?
M. Sangmai.
M. Sangmai, on behalf of নামটো আছে, with the consent of the other side has prayed for adjournment. List the matter after 2 weeks.
Ma'am,
Interim order.
Interim
Order shall remain in force till the next date of listing.
Lordship, I beg to mention for listing of IA.
PJ Soikia, Justice PJ, Devashis Purva. Justice before Justice Devashis Purva.
My lord, I beg to mention item number 15, analogous matter, my lord, 15 to 17. Can it be taken after due vacation?
Have you taken the consent of the
Yes,
other
yes.
side? Learned Counsel Mr.
S.K. Chakraborty.
S.K. Chakraborty, with the consent of the other side has prayed for adjournment. List the matter after due holidays. Will you be able to complete? Because from next week, this bench won't be sitting.
Just to but there's a limitation, my
Okay.
before that, my lord, my lord, whether the review application is maintainable before this one, there's a delay. Has given a judgment. Then appeal has been filed. Then in the district court also, district judge also some judgment has been given. Then second appeal has been filed here. Then second appeal has been allowed, remanding the matter to the again district court, district judge court.
My lord, 2,489 days.
And thereafter they have gone to Supreme Court. Supreme Court, after applying the mind, my lord, that there is no infirmity to interfere in the matter. In such a case, whether review can be filed before this court or Supreme Court.
No, review may not file the Supreme Court, my lord. That is a judgment of the High Court. So review must be done by the High Court. That is not a judgment of the Supreme Court. Why I am filing a review petition in the Supreme Court? Supreme Court has no jurisdiction to review.
No. They have gone to Supreme Court. Supreme Court has found that there is no infirmity in
No.
the judgment and passed.
Not.
Yes, madam. It will. So now, whether review lies this court or Supreme Court, there is a question mark. They have gone to appeal before the special leave petition matter.
Yes.
The Supreme Court on the first occasion in that 2015 stayed the interim judgment. Thereafter, Supreme Court has opined that there is no, I think mind has applied Supreme Court.
Supreme Court passed the order, my lord, like that, my lord.
I think Supreme Court has interpreted, they interpret whether the review can be filed here or there. I think it is there, Supreme
No, my
Court.
lord, High Court order
That is
may
affirmed
not
by the Supreme
review
Court.
by the Supreme Court, my lord. That is the order of the High Court. I am filing this review, the order of the High Court. Review the order of the High Court.
So according to you, case should not be admitted to merits.
No, yes, my lord. Because the Supreme Court has applied his mind. Review has to be filed before the Supreme Court.
Yes, you can place a submission.
No, my lord. Kindly see. I have filed as a plaintiff.
You are the appellant,
Yes. No.
petitioner.
No. Yes.
Yes,
Here is,
petitioner.
I am petitioner. Lordship, story of the case, my lord. I have filed a title suit as a plaintiff. My title suit is decreed. Thereafter, the respondents, defendant filed the appeal before the appellate court, first appellate court. Appellate court upheld the judgment. Thereafter, they have come to the High Court. High Court passed a judgment. And in that judgment, Honorable High Court passed some error is there. But after passing the judgment, I have come to Supreme Court and filed a leave petition, and that leave petition dismissed by the Supreme Court. And thereafter, case remand to the original appellate court. And appellate court dismiss and default due to non-appearance of the appellant. The respondent was the appellant in the appellate court. They are not appeared in the appellate court. That's why dismiss and default. And thereafter, I have filed an execution case. An execution case dismissed due to not a judgment for execution. And that error is in the High Court judgment. When the Honorable High Court passed this judgment, give a direction to frame an additional issue. And simultaneously, both the judgment is set aside. My lord, if both the judgment is set aside, that means there is no any other issue. So how it is come to additional issue? No other issue is there.
Okay.
Additional issue is there. So when additional issue not have and appeal is dismissed due to a default, no judgment is there for execution. Now suit is elite. Suit is not dismissed by the court. Now what is the position of the plaintiff? Where he will go? He can file a fresh suit? No, because there is no limitation. His suit is dismissed? No, suit is not dismissed by the court. So what will be if the judgment of the
You
Honorable
want
High Court?
review? What is the prayer for review?
review, my lord, that part, the judgment, both the judgment dismiss, both the judgment set aside by this.
That is his
If
submission.
my lord not set aside, if my lord not set aside the court, both the judgment, then there is one judgment for execution. Then now the position of the suit, the plaintiff is hanged in a middle course. He has no way to go anywhere because his suit is decreed. First Appellant Court also his judgment was upheld. The death part is not reviewed by the court, my lord. Then he will
Okay. On the delay, 2000 days.
delay, my lord, 2,489 days. That is a bona fide delay, my lord. In that part also, latest judgment was passed by this apex court, my lord, in one judgment. And in that judgment is very clearly stated by the Supreme Court, for the bona fide ground, my lord, that bona fide ground, my lord, it is delayed to file the review petition, my lord. My lord, relevant para, my lord, 32, 37, 38, 39, and 40, my lord, of the judgment.
32, 37.
37, 38, 39, 40, my lord.
Okay.
That's the very last 24th judgment, my lord. 2024.
And my submission is that, my lord, suit was decreed.
Yes.
Then thereafter, title appeal was filed. Title appeal was also dismissed. Title appeal was dismissed. Then second appeal was
Suit
filed.
was decreed in
In favor of
your
plaintiff.
favor.
Then title appeal was filed. Title appeal was dismissed. Then second appeal was filed. Now second appeal was filed. This honorable court, while passing the judgment, my lord, set aside both the judgment of trial court as well as appellate court. His problem is that I am not denying that. The trial is that this honorable court, while remanding the matter to make an additional issue before the civil judge too. Now, while doing so, that this honorable
In the second appeal, that both the suits were.
both the judgment has been
Both the
set aside.
judgment is set aside, my lord.
That-
By the direction.
wait,
One
wait.
direction is there.
No, yeah, both the judgment has been set aside. Now, what is the problem? They have gone to the Supreme Court thereafter. This plaintiff has gone to the Supreme Court. Now, Supreme Court has said the Supreme Court do not find any infirmity in the judgment and order passed by this honorable court. So, my lord, review if we find, then judgment that Supreme Court has applied its mind. First time Supreme Court has stayed the matter for nearly 1 year. Thereafter, after hearing the Supreme
Yes,
Court,
after 1 year.
yes, after 1 year, Supreme Court said that there is no infirmity in the judgment and order passed by this honorable court. So now, where the review lies? Until and unless the Supreme Court judgment is reviewed, can this court overrule the affirmation of Supreme Court?
And if there is, if your submission is correct, then there is no question of condonation of delay.
Because because review does not lie here. Review lies before the honorable Supreme Court. So this is my case, my.
Well, where it is, my lord? Kindly see the Supreme Court order, my lord.
Where?
Page 43, my lord.
In the IA or in.
In the IN.
He has given the Supreme Court's order.
Yes, my lord. No ground for the interference is made out to exercise our jurisdiction under Article 36 of the Constitution of India. The special leave petition is dismissed accordingly, pending petition, if any, stand disposed of. So there is no any observation of the Supreme Court, my lord. There is no any observation. Due to a jurisdiction, it is dismissed by the Supreme Court. So when I am going to review the judgment passed by this Honorable High Court, and Honorable High Court done some mistake to passing at the time of judgment. Because both the judgment, my lord, if the both the judgment set aside and were from coming one additional issue FEM. Honorable High Court give the direction to the appellant, first appellant court, the FEM a additional issue. So to be a additional issue, that means
No,
there must be.
when that additional issue is directed to be framed, that will be the judgment has been remanded, not set aside.
No, not set aside. So if this judgment is set aside and remanding to the court to frame the additional issue, madam. That is the point.
Judgment is set aside.
Let me submit. So
Judgment
that
set
is the judgment. Both as
I'll have to go through the judgment.
Yes, judgment set aside, my lord.
yes, madam.
Thereafter, they have gone to
No,
Supreme
no,
Court.
I am coming to High Court or judgment, my lord. I am coming to the High Court judgment. Kindly see the High Court judgment, my lord. High Court judgment, my lord, page 34, my lord. Relevant portion, my lord.
42.
42, my lord. May I read, my lord?
Yes.
As a result, this appeal succeeds and the substantial question of law of the formulate in answered in terms of the above, the judgment and decree of the court of the first instance as well as the judgment of the first appellant court are set aside and the matter is remanded to first appellant court in terms of the above. Parties are directed to appear before this first appellant court on C3/2015. That means direction. What was the direction, my lord? That is the earlier para, my lord. Relying upon the case of the Santosh Hazari and others, my lord, the paramount above the consideration being the need of the striking judiciary's balance and between the indispensable obligations to do justice of all the states and implementing such necessarily and avoiding the prolongation in the life of any its justice would be made by directing the first appellant court to frame an additional issue as to whether the appellant defendant is entitled to seek protection under section 53A. So that additional issue, honorable,
See, that judgment was remanded.
which one, my lord?
That earlier judgment was remanded. In clear words, it was remanded. High Court has remanded the judgment to frame and additional
Yes, my
issue.
lord. Judgment was remanded with a direction
As well as set aside.
as well as set aside. Both
As well
the
as set aside.
both the
Yeah.
judgment set aside.
At present, my lord, until and unless review is allowed, and my question only that which is the review court?
Review court is there.
Now, how can review? Because against this judgment, they have gone to the Supreme Court. Supreme Court
Supreme
says
Court, I have done
Supreme
for
Court
the
says-
appeal, my lord. I have filed the Supreme Court against this judgment. I have gone there for appeal. So my leave petition is rejected for the jurisdiction, not in merit. My appeal is not here. Supreme Court not heard my appeal, not my appeal dismissed. Only my leave petition is dismissed only for jurisdiction purpose, my lord. So now I am coming here. Otherwise, no way, if the Honorable High Court not review this judgment, my lord, what will be the position of the plaintiff? Review is most important, my lord. When I am filing a revision petition before this Honorable Court, my lord, against the order of the execution court, my lord, then, my lord, Honorable Court allow me to file the review petition, my lord. So that is the also order of the Honorable Guwahati High Court, my lord. That is page 49, my lord.
Page 40
49, 50 is the relevant part, my lord. Last part, my
of
lord.
the IA. Of the IA.
Yes, my lord. Page 50, my lord.
Mm.
In the aforesaid background, the learned counsel for the petitioner submit that he may allow to file a review application seeking review of the judgment and order dated 3/3/2015 passed in RSA number 42 of 2012. Such prayer is allowed. This revision petition is accordingly adjourned and list the matter. So next revision petition is pending here, my lord. After that, I have filed a review here. So that is the review court, my lord.
This is in the review petition.
Yes, my lord.
This order was passed. in the
Yes,
review
ma'am.
petition.
Not in the review petition, CRP, my lord.
The
I don't know.
CRP is there.
I
CRP,
don't know
I have
what-
filed. No, my lord, what happened then when the case remand to the appellant court again? First appellant court, that is the duty of the appellant to go there, but they are not appear in appellant court. Because they have that both the judgment was set aside by this Honorable High Court. That's why they are not appeared. When they are not appearing in the appellant court, appeal is dismissed due to a default. They are not appearing there. That's why appeal was dismissed. And thereafter, wrongly or rightly, I filed the execution case before the execution court. Execution court, when going to hear the matter, and when they find there is no any judgment to execute, that's why my petition was dismissed. And thereafter, I have come to the Honorable Guwahati High Court for a revision, my lord. And at the time of revision, I have taken the leave and Honorable Court allow me to file the review petition. Accordingly, I have filed a review. And the delay is the totally bona fide delay, my lord. Totally bona fide delay. There is no any negligence of the petitioner, my lord. If the review not done, my lord, then what will be the position of the plaintiff? Where he will go? His suit is till now elite, my lord.
He has already said, no? You can go to the Supreme Court also.
No, my lord, Supreme Court already I have gone there for appeal, my lord, against the judgment. Against the High Court judgment, I have filed the appeal. But filing the appeal, before filing the appeal, leave petition is required. And I have filed a leave. The leave is dismissed. That means appeal is not taken for the hearing. Until to hear the appeal, Supreme Court not given any verdict on it, my.
All right.
So my lord, it is my humble submission. It maybe allow me, and if it is not allowed, the condonation delay is not condoned, my lord, then the petitioner will suffer a loss and injury, my lord. What his position, my lord, where he will go?
Yes.
Because genuinely he is genuine person, where he has got his property, my lord. That property they have enjoyed. Till now they are enjoying my property. Since 2006, I have filed this suit in the year of 2006, my lord. They have enjoying this property. They are not intentionally not appearing the first appellant when they remaining the appeal, my lord. Why they are not appeared here? Why they are not contesting there? They know that there is no judgment. If I am going to execution, there will be no judgment. Then they will fail. So that is not, my lord. Due to a fair judgment, my lord, it should be allowed, my lord.
Yes.
Yes, my lord. This honorable court in the CRP, my lord, I also agree that review, he has to file a review. In the aforesaid, that's page 50. In the aforesaid background, the learned counsel for the petitioner submits that he may be allowed to file a review, seeking review of the judgment and order dated 3% of the RSA. Such prayer is allowed. Now the question that honorable court did not say where is the review line.
Oh, yes.
This
Yes, I'm not saying this.
Please let me submit. Where is the review line? Because there is an order of the Supreme Court. Because Supreme Court at the first instance in the year 2015 has stayed the judgment and order of this honorable court. I have given here, Lord say. After that, Supreme Court says the Supreme Court do not find any infirmity. That is, no ground of interest made out to exercise our jurisdiction.
Yes.
Means appellate jurisdiction. So and so, the appeal leave petition dismissed accordingly. Now, where to file? Because there is no judgment to exercise, no judgment to execute. Now, whatever this honorable court has directed to additional issue to be determined, but at the same time, this honorable court set aside both the judgment. Now, this judgment is to be reviewed. The trial court judgment is to be, my lord, executed, but there is no judgment because set aside. Now, why to be reviewed? Now, let him say how, why. Because they have gone to Supreme Court. After 1 year, Supreme Court observed this issue. Now, necessarily, my lord, I don't know this honorable court may overrule the yes, the authority of Supreme Court. My lord.
No,
So
that
this,
is not.
This is my submission.
No,
And
that
the-
is not.
and-
That
and-
is very much wrong,
and
submission,
the-
my lord.
and
Because
the-
Supreme Court not saying anything on
And
my
in the-
appeal.
No, no, just a moment, just a
and
moment.
in the CRP,
On the condemnation of delay, I understood.
yes,
I understood both your submissions on
Yes, ma'am.
this review petition, but on the condemnation of delay,
condemnation, there is no explanation. Whatever here, day-to-day explanation is not there. That is my submission. It is not the condemnation should not be for reversal. I support that so the condemnation must be reversal, but day-to-day explanation is not there. Paragraph 3 in my objection petition. Paragraph 5, page 56. Running page 56. ma'am. Answering referent further best to state that the delay cannot be explained properly, was not explained properly. The petitioner has also not explained the day-to-day delay, and the petitioner has failed to establish the sufficient cause in this case. There is casual and careless approach on the part of petitioner in explanation of delay. There are no cogent and plausible grounds in the petition filed by the petitioner. The delay of 2,489 days, as explained in the petition, is in casual manner.
I'll have to pass an order later.
Yes,
My lord, in this regard, my lord, my little submission is there, my lord. Already I have clearly stated here that is a bona fide
Yes,
ground of the
that is
delay.
noted.
So decree was passed 13/8/2010. Already I have explained here. Thereafter, appellant court passed the order 25/8/2011, my lord. Thereafter, my lord, second appeal filed.
That is given serially.
Yes, my lord. Yes, my lord. Yes, my lord. That's all the I have.
All the days added
Yes, my
together,
lord.
tender
All days
months to
are
2,489.
I have withdrawn 1/8 due to some mistake. I have withdrawn the petition 8/1/2024 with a liberty, and against I have filed 11/1/2024. That is very much clearly I have stated in my petition.
All right, I'll pass an order,
My lord.
but not today,
yes, madam.
some other day.
Yes.
My lord, if
Headache,
the review is not done, my lord,
judgment.
then it will be suffered, my lord.
CAB क्यों deliver? Deliver होता है CAB का कब पे?
নাম তো আছেই মধ্যে। মাসুদ।
Item 3. Made seizures is Lordship. Lordship, in this case, what happened, the appellant company adduced evidence that there was no policy. But the learned tribunal relied on a photocopy given by the claimant. Not even the owner did not come, and discarded our evidence and then passed the judgment. There is no policy, Lordship. Our High Court judgment I have in another case where there was no policy. High Court observed that how can negative evidence be given? The court said that in the written statement it was not mentioned that it was a fake. We are not talking about fake policy, Lordship. There was no policy. So that is main ground, and then on quantum also we have taken.
Lordship, we have not, we are not served the appeal.
No, after admission only we serve it, Lordship. Before admission there is no provision to attempt serving. So, Lordship, the appeal may be admitted, and since they are appearing, we will take steps on the rest of the. I think you are appearing for 1 to 3. She is appearing for 1 to 3, Lordship. For 4 and 5, we will take steps.
Learned Counsel Ms. R.D. Mozumdar is present for the appellant, insurance company,
Yes, Lordship.
and has submitted that the order dated 30/11/2022 has been erroneously passed by the member MACP, MACP, Bishwanath Sariali. It is submitted that there was no insurance policy
No policy.
and the insurer is not liable to pay the compensation. In the move appeal, admit Learned Counsel Ms.
M. Nirola.
M. Nirula is present for the
Number 1.
respondent number 1 to
3.
1, 2, and 3. 1, 2, and 3. Appellant to take steps to issue notice to the respondent number. How many respondents?
4 and 5, Lordship.
To the respondent number 4 and 5. Meanwhile, call for the trial court records. List according returnable liquidia. Notice returnable within 4 weeks. Meanwhile, call for the trial court records. List accordingly.
Shall you oblige, sir?
Just in that, madam, order 47, rule 1, madam. Just your lordship kindly, madam, look into in my submission.
Sure.
Order 47, rule 1. The
I have
review
to look
application,
into it.
if appeal filed, no review line. This is the 1 point. Order 47, rule.
I'll convert it.
My lord.
Order has already been passed.
Yes, ma'am.
Today's order, I'll convert it into, we'll get it converted to appeal.
My lord.
To correction probably. I had to dispose of.
That's why we were wondering, Lordship, whether IAS come up, Lordship.
No, actually, that day I didn't have sufficient time to pass the order. So yesterday I
But you
got the order typed and corrected.
Blessed.
It's converted to appeal.
This is the lordship. It's a 483 application, my lord, and the petitioner before your lordship was arrested on 19/3/2022, my lord. And he's facing a trial for the London Court of Special Judge at Perryman's, my lord. What happened in this case, my lord, he, along with his owner, my lord, Sajan Ahmad, took a lift in a vehicle, my lord. And when the vehicle was, my lord, stopped at the Naka checking, it was searched, and from the backseat of the driver, my lord, driver's backseat, some contraband weighing commercial quantity was recovered by the police. And thereafter, my
People
lord,
lived in a vehicle.
yes, my lord. He,
So he is not involved.
no, my lord, he along with his owner, my lord, Sajan Ahmad Borguya, they sell, my lord, plastic utensils from house to house, my lord. And, my lord, thereafter, charge sheet was laid in this case. Charge sheet was laid on 15/6/2022 by the prosecution citing 11 witnesses to prove their case, my lord.
How many witnesses?
11 witnesses, my lord.
So how many have been examined so
My
far?
lord, till date, only 3 witnesses examined, my lord. And thereafter, my lord, no examination. With last examination took place on 12/4/24, my lord. And when, my lord, the co-accused, his owner, my lord, approached before this honorable court, page 46, my lord. Lordship was pleased to consider
what?
his co-accused, my lord, Sajan Ahmad Borguya, his owner, my lord, approached this honorable court. The Lordship was pleased to, my lord, grant him, considering the prolonged incarceration and relying on some of the Supreme Court decisions.
Co-accused.
Yes, my lord.
Just a moment. This last witness was examined when?
12/4/2024, ma'am. I have annexed, my lord, in my application.
Mm.
It is PW3, my lord, page 39.
Page 39.
No, my lord, it starts from 38, my lord. I have annexed. 112. So far, with depositions were recorded.
So
my
who
lord.
is co-accused?
Uh,
The owner.
No, my lord. No, he's not the owner. He is the owner of employer of Mr. Present petitioner, my lord. He works under Sajan Ahmad Borguya, my lord. They sell, my lord, plastic utensils that we used to buy on 10 rupees products. They used to sell this house to house, my lord. It's a 23-year-old boy, my lord. My lord, today, my lord, it is 1 year, 11 months, 25 days as on today, my lord. 1,090 days, almost 3 years, my lord. And there is a very remote possibility that
He is behind bars for 3 years.
yes, my lord. Exactly, it is my lord 2 year 11 month 25 days. Page 46. Lordship was pleased to, my lord, considering the prolonged incarceration.
Co-accused.
Yes, my lord. Oh, co-accused, my lord. I have annexed, my lord, at page 46. Lordship. Putting in some stringent condition, my lord.
What about the contraband? What is the contraband?
10,000 Yaba tablets, my lord.
How many?
10,000 Yaba tablets. It was recovered from the driver's seat, my lord.
Anything else?
So, my lord, my prayer at this stage, my lord, was to consider my present application on 23 years old boy, my lord, living family. Every any stringent
Family also.
yes, my lord, is a married. What I have been told, man, is a married man.
Lordship, in the intercepted vehicles from where the contraband has been recovered, there were 3 occupants along with the petition. 10,000 Yaba tablets, which is speaking about 1.00 kg of tramadol.
How much kg?
1.00 kg. 1 kg.
1 kg.
One.
Only 1 kg.
Methamphetamine.
Methamphetamine.
Methamphetamine. Oh, that is great. That is a huge amount.
Yes.
1 kg of methamphetamine tablets.
Yes. We have the reports up to PW3 has been examined.
Yes.
As of 11 witnesses. So, Lordship, you call for the status report. What is the present status?
My lord, that is the very up-to-date records. 1-3.
PW3
Please given the up-to-date records.
Yes.
as
Very,
according
it is received by the registry on 11/3/23 up to 1/3/2025, my lord.
PW3, he was the last
Yes.
prosecution witnesses we examined in the year 2024.
Yes. 12/4/24.
2024.
When was the next date fixed?
Next
You have
date-
the order.
My lord, I have checked in this e-court. It was April. I'll just provide the date, my lord, next date.
No. In the month of 11/23, when was the next date fixed? February maybe.
No,
Because they take 2 months, I think. If in Kamrup,
April, my lord. April, just possible.
in Kamrup they fix this case after 2 months.
Yes. So, the call for the up-to-date status report. Only
My lord, records are very much up to date.
that
Yes, the records are very much up to date, my lord.
huge quantity of methamphetamine.
But you see,
Lordship.
only 3 witnesses have been examined only.
Yes, that's what I'm just.
My lord, the PWs are all
What is the present status?
PWs were already there, my lord. They have sent the entire records. The records are up to date till 1/3/2025. I have checked, my lord.
When is the next
1/3/2025.
Yes, my lord. Lordship, verify, my lord. I'm not.
1/3/2025.
Last order, my lord. There.
Only 1 week.
Today is yes, my lord. So, my lord, my prayer at this stage, Lordship, kindly consider. I'll regarding next date, my lord.
Let's see how this. I'm dictating how this progresses. Let's see.
Yes.
I don't know. I'm dictating. Third learned counsel, Mr. M.A. Chaudhary, for the petitioner. Rubel Ahmed Bobnia, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as he is behind bars since 19/3/2022 in connection with special NTPS case number 47 of 2022 arising out of Karimganj PS case number 190 of 2022 under section 22 within bracket C bracket close stroke 25 stroke 29 of the NTPS Act. It is submitted on behalf of the petitioner that he is behind bars for more than 3 years, 11 months.
So, my almost 3 years, my lord.
Oh, 2 years, 11 months.
2 years, 11 months,
For
25
more
days.
than 2 years, 11 months. His right to personal liberty has been infringed as only 3 out of 10 enlisted
11
witnesses have been examined.
11, 3 out of 11 witnesses.
3 out of 11 enlisted witnesses have been examined so far.
Yes.
He is only 23 years
Yeah.
old and he is the sole breadwinner of the family.
Page 38.
He on the relevant day he was taking a lift in the vehicle, which was later intercepted. And how many Yaba tablets?
10,000, my lord.
10,000 Yaba tablets were recovered from the vehicle. Full stop. It is submitted that the petitioner was not aware that the vehicle was transporting contraband. The petitioner has also submitted, has prayed for bail on the ground of parity as co-accused. Which page?
Sajan Ahmad Borguia, my lord. Page 46. Lordship. Sajan Ahmad Borguia.
As co-accused, Sajan Ahmed Borbuya has already been enlarged on bail by this court by order dated 4/12/2024 in connection with DA number 2881 of 2024. It is further submitted that that possibility of conclusion of the trial appears to be remote due to the procrastination of this case by the trial court as well as by the prosecution. As the up-to-date status report of the pendency of the trial clearly reveals that recently no witness has been examined after the third witness was examined on when
12/4/2024.
learned additional PP Miss S.H. Bora has raised serious objections stating that learned additional PP, Assam S.H. Bora has raised serious objections stating that considering the gravity of the offense, the petitioner is not entitled to bail on the length of detention on the ground of length of detention or on the ground of parity. The use cache of methamphetamine, no?
Methamphetamine.
Phentamine.
Yes, ma'am.
Methamphetamine.
MEAMPHETAMINE.
Tablets were recovered.
50 grams is the commercial one.
Huh?
50 grams is the commercial.
50 grams only. I'll see the last order, huh? Why your co-accused was granted bail?
Yes, it is there, madam. Lordship, a page, Lordship has discussed some of the Supreme Court's judgment, my lord. I have also brought this one for Lordship perusal. And paragraph 8 indeed was the finding of this honorable court.
It is further submitted by the learned additional PP that the commercial quantity of such tablets is only 15 grams, whereas in this kg, in this case, 1 kg,
1 kg,
1 kg.
2 grams.
1 kg, 002 grams.
Yes.
1 kg,
2 grams.
002 grams of tablets were recovered from the possession. Because of the submission that the procrastination of trial outweighs the rigors of section 37 of the NDPS Act cannot be accepted at this stage. I've considered the submissions at the bar with circumspection. It appears that trial has indeed been dragging on with a laden feet, LEADEN, laden feet. 8 witnesses are yet to be examined. It is. Do you have any antecedent?
No, madam, no. The charge sheet is very clear, madam. No antecedent.
It is submitted that the charge sheet is very clear and no antecedent could be, and no earlier criminal antecedent could be projected by the prosecution.
Page 23.
it is also submitted that the petitioner is a young lad with a family, young lad of 23 years with a family. Full stop. It is further submitted that the petitioner is willing to cooperate with the remaining part of the trial. Full stop. The petitioner being a local resident is not a flight risk. Considering all aspects, he is from this locality or from
Yeah.
other state.
No, Malak, for the Karim Malak.
Considering all aspects, the petitioner is enlarged on bail of rupees 1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall cooperate with the trial. Number 2, the petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial. Number 3, the petitioner shall refrain from such activities with which he is alleged. Full stop. The trial court may also additionally impose conditions to secure the attendance of the petitioner.
DP of the
Item 5.
With legal lordship. CD was called for lordship.
You have the CD?
Yes.
Lordship, all the sections are below 3 years punishment lordship. I may be allowed to go on 3 years bail lordship. And I will cooperate with the investigation. Interim.
Where is the FIR?
FIR in page 11 lordship.
Please read.
I would like to inform you that today at around 9:30 p.m. I was driving towards Lokra from Ganeshgiri with my friend Noor Islam in my vehicle, bearing registration number so and so. As I reached Jyotia petrol pump, I was stopped by 10 to 15 persons who came in a Kia model car, white color, and started taking out all sorts of sharp weapons, hockey sticks, and dagger-like objects. They asked me to step out of the car and tried to force me by grabbing my neck. As soon as I realized the fact that their intention was to harm me to death with those weapons, I fled the scene immediately. Well,
All right, all right. Yes, yes.
Lordship, otherwise, the informant is the victim, Lordship, who has indicated the particular. When he was driving a vehicle, Lordship, his car was stopped by the present petitioner along with his friends. Thereby, he came with lethal weapons, armed with lethal weapons, with the intention of attacking. Thereafter, they have grabbed the neck of the present petitioner and taxed it with a gold plate. So that is clear from the victim statement along with the other
Punishment all are below 3 years.
Lordship.
All the sections are below 3 years.
But no
I don't want to check. I'm just relying on your submission.
Lordship otherwise.
These are all BS sections.
Yes, let it be on interim.
Not very familiar with, huh?
Let it be on interim. Thereafter, Lordship may give him
On interim,
let him
after
appear
going
before
through the CD.
Lordship kindly goes through.
I will appear before the IO.
I'll just check the statement of the victim.
But sure, earlier interim was granted, but due to some misunderstanding between the conducting engaged council, earlier council, and the petitioner, and the petitioner was withdrawn.
Petition was withdrawn
Was withdrawn.
and interim order was vacated.
And
Or not vacated.
interim order also annexed here in case 14 Lordship.
What is your petitioner's name?
This was Toledo.
Okay, that's the main accused. He's the main
He's
accused.
the main.
The actual fact of the case was that there was an
Not
accident.
required. I'll just check this.
All sections are below 3.
Yeah. Any injury report?
No.
Hard learners council, Mr.
B. Ali Estate.
B.
B. Ali Shekler.
B. Ali Sheikh for the petitioners. Petitioner 1, petitioner.
Petitioner 1 and 2 lot.
Petitioners Bishojit Dole and Asik Rahman, who have filed this application on section 482 of the BN with prayer for creators bail as they apprehending arrest in connection with so-and-so PS case under so-and-so seconds. Third, Organization PP Assam, Ms. Asik Bora, who has raised years objection stating that the petitioners are not entitled to anticipatory bail as they are incriminating materials in the case diary against the petitioners. Full stop. The allegation against the petitioners is that they, along with their gang, along with their, their other other miscreants attack, armed with sharp weapons as well as hockey sticks, etc., attack the informant and snatched away one gold chain and snatched away one gold chain, or he had grabbed him by his neck and snatched away one gold chain. Any recovery of gold chain or something like that? It is submitted that a is submitted that.
And out of that incident, 2 persons arrested.
Oh,
Already.
persons have already been.
Yes.
This
He's the main.
he is a main.
What to kindly from the
Last page of the CD.
and there is a bail objection prayer also. In the first case. 2 persons arrested.
Yes. Something more has also emerged. There are victim girls also.
Probably no whether victim is the complaint.
No, but here it is mentioned. Recovered the victim girls, medical examination of the victim girls. Nothing about any victim girls and recovery of victim girls. Nobody has apprehended any victim girls. No, nobody has confined any victim girl.
No, no. There are 3 persons in the way.
There must be some. These 2 persons are not related to this case. Who have been arrested?
No, why is their names is given that I know. Can you see the bail
The
objection?
name, nobody's name.
Yes, but so many persons. 10 to 15
10, 12 persons.
Yes.
I don't know from where these 2 victims they are mentioning about 2 victim girls.
Yes. But the fire, the person of the complainant reflect about it. So,
Dispur PS case ni.
911.
Dispur PS case 911 of 2024 ni. One I know. Or Dispur PS case 911 2024.
There was a scuffle between two groups.
Two groups.
On 30/09/2024, your lordship has granted interim stay to the petition. Thereafter, I think they have this order has been vacated.
Not vacated, actually withdrawn. The petition was withdrawn. Due to misunderstanding of the earlier council.
Page 14. It was granted on 39/2024. Lordship, they have withdrawn the petition on 18/11/2020. In between 9 to 11, 2 months, whether they have appeared before the IO.
Not appeared.
They withdrawn and did not appeal.
Later on, they have withdrawn. It was granted on 39 and petition has been withdrawn on 18/11.
Why did they withdraw the petition? That is also
That
mystery.
was correct. Yeah, take it. Take it. Okay. Present petitioner council is the newly engaged council. Is the
And the newly engaged counseling.
Can be granted, I think. Ah, it is subject on behalf of the petitioners that they have been falsely implicated in this case. It is I have also raised serious objection materials in the case diary. I have also scrutinized the case diary in detail materials in the case diary against. Full stop. I have considered the submission that the petitioners are willing to cooperate with the remaining part of the investigation. The petitioners are local residents and like this, the petitioners are willing to abide by any stringent bail conditions if imposed upon them. Considering all aspects, petition is allowed in the event of the arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a total surety of like amount each 30,000 each with a security of like amount to the satisfaction of the jurisdictional satisfaction of the Elega magistrate, jurisdictional court and Calicut. Oh, and the arresting authority. To the satisfaction of the arresting authority under the condition that the petitioner shall appear before IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall refrain from such activities which they allege. Number 3, the petitioner shall appear before the IO on every fortnight till completion of investigation. And number 4, the petitioner shall not leave the jurisdiction of the court without prior permission on breach of any of the bail conditions. Bail order shall stand automatically cancelled. Send back the CD.
Obliged.
You appear before the IO within 7 days.
Obliged.
Oh,
I can see.
oh. You'll have to convince me once more. I thought of passing an order, but I didn't get convinced. I'll have to hear you thoroughly once more.
Then Lordship on some other day.
Some other
I
day.
was expecting maybe your Lordship is admitting today itself, Lordship. So then some other day, Lordship, after 1 week or.
All right. Learned Counsel, Miss.
I have
No,
already cited few
I have gone
decisions,
through it.
Lordship.
Then you have raised some substantial question of law,
Lordship.
but I think I'll need another hearing,
Lordship.
thorough hearing.
My case is that, Lordship, they have pleaded their case in the plaint, whatever they have pleaded, they can adduce evidence only on the basis of that pleading. But beyond pleading, they have pleaded that
Yes,
in
yes.
the meantime, the
I-
property was given.
I have noted it down. It was there.
Lordship. Lordship.
Then again I thought I'll need one thorough hearing after
Lordship.
going through
Then,
the
Lordship, I'll try to bring on some more citations, Lordship, to convince your Lordship on some other day.
as prayed by the learned counsel for the appellant, list this matter after 1 week.
25, Lordship, or 24,
Okay.
20. Obliged.
May I please, my lord? Very short matter compelled me to come, drag us to this honorable court, my lord. A very short prayer before the learned court. With that prayer was already allowed by the civil judge. Then the matter was again transferred to the municip at Margarita. So again we made a prayer to call for a document, a SLD, to which the defendant also.
What do we have today?
No, we can dispose it, madam. My lord. My limited submission is the defendant did not raise an objection. It is reflected in the judicial order for calling of this sale deed. The facts remains, my lord, at the time of execution of the sale deed, everything has been signed, register was present, the execution was done. Then the vendor took away the sale deed and get out from the place of the registrant office or the place of the residence. Then we have filed a civil suit for execution for passive performance of that registered sale. That sale deed was seized by the police. We filed an application before the civil judge when pecuniary jurisdiction lies with the civil judge, praying for call for that deed of sale for exhibiting the same by the plaintiff, because original sale deed lying with the police, lying with the defendant. We say because we do not know whether the police has seized or not, because defendant has carried out the take away the sale deed. So we pray before the land.
There was a criminal case, maybe.
The
snatching away or something.
Yes, yes.
Maybe, yeah.
So we pray before the land civil judge to direct the defendant to produce the sale deed, because on record the sale deed was taken away by the defendant. Now defendant appeared and saying that the sale deed was not in our custody, it was seized by the police. Then we have taken steps for calling the records from the police of that sale deed for the purpose of exhibiting, because original sale deed is required to be exhibited. The police says that we submitted the final report. Case was closed, that criminal case. And that sale deed was with the SDGM court at Market. Then we pray before the learned Munsi. Meanwhile, the case was transferred to Munsi. That record may be called for, which was disposed of. Learned Munsi passed an order to get a certified copy of that sale deed and to exhibit. That is unregistered sale deed. And that certified copy, Lordship is also aware, signature will not, that we have to prove the original signature. This is the main foundation of entire case. And the defendant did not object. But the Munsi says that no, you obtained a certified copy. Therefore, we are before this Honorable Court. Lordship, kindly have a look at the impugned order. Lordship may dispose it. It is absolutely small matter. Page 61. And after, in the suit also they did not appear. No. This is the difficulty though. 61, my lord.
Yes, yes.
The plaintiff, Sergeant Sir, the instant petition filed by the plaintiff on 30/8/2022, stating that the plaintiff has taken steps for production of the document seized by the officer in charge Digboi Police Station, Digboi PSK. But the same has returned with a report that the final report has been filed by the investigation officer before the learned court SDGM Margarita, such and such, by FR case number. It was not charge sheeted. It was FR case. Hence, the plaintiff has prayed that there may be a call allowed to call for the record of FR case number such and such, as the document that are needed to be called for or are annexed with the case diary of record of the PS case number such and such. Whereas the learned counsel, this is important, learned counsel for the defendant has not objected to the prayer of the plaintiff. On such perusal of the case record, I am of the belief that this court had already allowed the calling of the document. However, since the FR case is pending before the court of learned Senior Margarita, I am of the belief that the calling of the record might lead to undue delay. Now, the learned Munsi don't understand. This is a case of FR, final report. It's not charge sheeted. So there cannot be question of a delay of any prosecution.
Maybe she was waiting for the FR to be accepted or to be denied.
No. This is not a. She says calling of the record because that is filed long before that FR.
FR also it takes time to come up before the CJ.
And also might disturb the proceeding. The plaintiff is, however, at liberty to file the certified copies of the document since seems they are the public document. The learned Munsi could not know.
Actually,
this is a very sorry state of affairs, my lord.
No, you can take the copy from the.
No, this is a very sorry state of affairs of the officers concerned. This does not know that a unregistered sale deed is not a public document.
No. That's beside the point. There are so easy ways also. You can apply for the copy and give a certified copy in a disposed of cases.
No, I cannot.
In that FR, suppose it is disposed of.
No. The original executing signature, etc., that has to be exhibited.
I understand.
So therefore, and
this
this is a next door court. This is a Munsi, this is SDG.
That is what I am saying. Yes.
The record may be called for. Lordship may just direct call for. If it is pending, it will again return back after the exhibiting the document. This small issue now is carried out, my lord, in 2022, now 2025. And since they have not objected, they did not contest this case. They did not object to the prayer. How Munsi has passed this order, my lord? Absolutely erroneous. This is a not charge-sheeted case, final report. And therefore, the entire you could not file the PW evidence is pending since long. Only mistake committed by the London Magistrate. The delay has been put. 2022, the order was passed. Now 25.
If I can be called and be sent back. Can be sent back.
Yeah.
The record can be called and be sent back.
Final report. Final, no protest petition. And court should understand what is certified copy, what is origin. What is public document? What is private document? It is absolutely private
She didn't
document.
mention about any public or
Yes,
private
he
document.
said the
Where?
certified copy you have to obtain since it is a public document.
Oh,
It is
yes.
admissible. Yes,
Last line.
yes. It is not admissible in evidence, my lord. My entire case will go. And therefore, I am compelled to challenge this order before this honorable court. Lordship, kindly allow this. Let the proceeding be continued because stay order is there.
I can just set aside the order and then she'll have to pass an order.
Yes, fresh order.
I'll
Yes.
just set aside.
Yes, yes. And by observing that since it is another public document, my lord, is just a the certified copy is not admissible in evidence. It is not a public because unless learned this honorable court saying that it is now not a public, then there may be a because any judgment of the higher court will give a lesson of the to the lower court also, district court. So Lordship may kindly have held it that is in a public document, the record is necessary. So therefore, a fresh decision may be taken by the Lord. Otherwise, how could the Munsif could know, my lord, how to, I cannot say to teach the Munsif, my lord, what is public and what is private. My lord can only teach. My lord can pass
Set
letter.
aside the order. I
Yes.
don't have to give summons. I'll just set aside the order.
Well, I'm
Why
just,
should I hold it? It's not a public document. It's not required. I'll just set aside the order.
how could know, the Munsif could know, my lord, that he come to a wrong conclusion. This is a public document. Section 74, 63, they are all to be read by the court, my lord. The all important section of the Evidence Act.
But you have given a long petition. Where is your ground? The petition?
Grounds are there, my lord. It's a simple petition I have filed here.
Not simple. Elongated petition.
It's a simple petition. The facts of the suit I am telling, my lord.
Oh. I'll come back after 5 minutes. I'll pass the order. I'll set aside the order.
My lord.
Yes, yes.
And send back the.
Sorry, Lordship, on next week, your Lordship is.
My bench is not there. Yes.
At 2, Lordship.
At 2? All right. Okay. Can you cut it order?
The lordship, lordship may pass. I mean, other may pass the order. In camera.
Yes, junior may stay or you may not stay. I'll pass an order.
Oh, no.
You don't worry.
Thank you.
I have given my word. I'll set aside the order.
Grateful.
After 5 minutes.
Grounds are case paragraph number 16, 17,
For the applicant Vikas Agarwal.
Yes.
PID. So, one AC to live on. Who has filed his application under Article 227 of the Constitution of India.
Impugn order dated 26/9/2022.
Challenging the order dated 26/9/2022
22.
passed by the learned Munsif.
Munship Margarita.
Munsif 1.
Munsif
One
Margarita.
Munsif only.
Only one.
One only, no? Munsif Margarita.
Yes.
Munsif Margarita.
In petition number 1108 public 2022, arising out of title suit number 40 oblique.
No. In TS number 40 of 2021, dismissing the petition filed by the applicant, filed by this applicant,
Yes.
stroke plaintiff, despite the fact that the defendants who are arrayed as respondents
Yes.
stroke opposite parties in this respondents opposite party nahi. Respondents in this petition have not raised any objection against the petition. So it is further contended that it was erroneously observed by the learned Munsif that as the document is a public document, the certified copy of the unregistered sale deed will suffice.
Our grounds in the petition at paragraph number 17, page 13, 17, 18 are the main ground.
It is contended that the petitioner stroke plaintiff in his plaint has categorically stated that the original sale deed in question was illegally taken away by the defendants. Stop. The court, after considering an application filed by the plaintiff stroke petitioner under Order 12, Rule 8 of the CPC, while order dated 14/8/2019, was pleased to direct the defendants to produce the original sale deeds for considering the facts or to decide the title suit number 40.
Title suit number 40/2021.
40/2021. 21 nahi?
21.
The petitioner had to file a petition dated 30/08/2022 as the defendants stroke respondents informed the court that the sale deed is not in their custody as the Digboy PA police and the Digboy police had also reported to the court that the sale deed, which is an important document, is at present as present annexed with the record of FR number 249 of 2021 in the court of the SDGM Margarita.
Then 18.
It is about that it is about that the funding of the court of the Munsif, that calling of records might lead to undue delay and disrupt the proceeding of the case is not at all tenable in law. The certified copy as directed by the court to be produced as evidence is not sufficient to prove the execution of the sale deed. Most of the signatures in the sale deed are required to be proved. It is further averred that in a mechanical and casual manner, the impugned order was passed. I have considered the submissions at the bar, and I have also submissions at the bar. I have considered the submission by the petitioner, and I have also scrutinized the record. Scrutinized the order dated 26 impugned order dated 26/9/2022 in connection with TS 40 of 2021. The record, the order clearly reflects that the defendants also had no objection if the trial court or if the record of FR number 249 of 2021 is produced to prove the sale deed, which is a part of the record. it is also further submitted on behalf of the petitioner that there is no bar in calling the record and later sending it back to the court after proving the sale deed. I find force in the submissions of the learned counsel for the petitioner, thereby the order dated 26/9/2022 is hereby set aside. So you will file a fresh petition to
Lordship may allow that petition here also. Because there is a
that
prayer.
petition.
Yes, Lordship, there is a prayer also. To allow the petition number 1108/2022, page 16.
How can I allow this petition here?
Your Lordship, if Lordship is held that the or impugn order is bad,
I have set aside, yes.
yes, then Lordship automatically this petition has to be allowed.
This is Article 227 of the Constitution.
Yes, Lordship. Has the power, supervisory power.
Direct the petition to consider petition afresh. The learned court of the learned Munsif is thereby directed to consider the petition afresh and pass necessary orders.
Yes. And
In terms
hearing
of
may
the-
be vacated in view of because
Hmm?
proceeding has been stayed by this order.
Okay.
The date has to be fixed by this honorable. Any date.
The interim order dated 12/1/2024 passed by this court.
Trans-
No, not to, it did to be like 18/11/2022
Yes,
passed by this court. The order of stay of further proceedings of TS number 40 of 2021 stay is vacated.
vacated. And a date may be fixed also for appearance.
The petitioner is what appearance date?
No, because proceeding has been stayed, no date has been
Ah.
fixed thereafter. The date has to be fixed by this court.
The
Petitioner is directed to appear on.
you will appear, definitely you will appear.
will be
You will appear in,
Yes, that's it.
the defendants may appear or may not appear. You will definitely appear. In terms of the above observation, revision with CRP stands disposed of.
Item 8.
Yes.
We have to the respondent.
Yes.
You are not fix the date of hearing, you are not.
Fix a date for you.
Yeah, record number.
This is for orders.
It's for order.
Okay. Yes.
Lordship, LCR has been received, but it has been tagged up with item number 9.
They're common, a common judgment. They get one
So
common
both
judgment.
8 and 9 we will
Eight
fix
days
it for
you have to
hearing
do.
then.
Yes.
Yes.
Your lordship fixed till 17th of June.
Date.
It's not matter, it's not a fixed matter, your lordship.
Learned Counsel Mr.
Speech order.
P. Chaudhary and Mr. V.K. Chandok. Oh, respondents, Learned Counsel Miss
D. Devi.
D. Devi. Learned Counsel Miss D. Devi is present for the appellants. Learned Counsel Mr. Cavitas. You are Cavitas.
Provit Chaudhary.
No. Respondents only, not caveators.
No, we have.
This has already been held, substantial question already been framed. It has already been admitted also.
admitted.
Okay. Learned Counsel Mr. P. Chaudhary and Mr. V. Chandok is present for the
Respondents in both the case,
respondents. দুটা case একেলগে লিখি দিবা।
1 and 2.
V.K. Chandok লিখি দিবা দেই। For the respondents,
Two respondents.
only 2 respondents,
Yes.
no? For the respondents, LCR has been called.
Yes,
by-
both.
LCR has been
Just common
received.
LCR.
Huh?
It's in item number 9.
Oh, yeah, yes. More দেখা নাছিল। LCR trial court record is received. List this matter for hearing after you want a date.
Yes, sir. Keep you. Yeah, and highly aware.
It is item 23 for orders.
Lordship, my senior is in leg in another court, Lordship. Can he pass up for the time being, Lordship?
Order only, let's see what we have.
Lordship, I did the title to us. Oh, what is it?
My lord, I filed the IA for condonation of delay, my lord. My lord, let the senior come.
Ah,
my lord.
yes.
Yes, my lord.
He has to come.
Number 11 for hearing.
Video kita bung ko dia.
May it please your lordship.
Just a moment. The appellants are not represented today. Learned Counsel, Mr. T. Chaudhary is present for the respondent. Is this matter after 3 weeks?
A date maybe.
Huh?
A fixed date maybe.
Date. Is this matter for hearing positively on? Failing which necessary orders may be passed.
Highly
Item 18.
It means your lordship.
Mm.
Engaged counsel is out of session today. I'm paying for an adjournment today.
All right. Learned Counsel, Mr.
R.A. Lawker.
R.A. Locker, on behalf of Learned Counsel.
R. Sensua.
R. Sensua on behalf Nalage has submitted that the Learned Counsel for the petitioner is out of station. Learned Counsel for the respondent, Mr. A.K. Gupta is present. Is this matter after
26 March.
everybody wants a date?
Let
This
it be
matter
a-
of 2023, no.
let it-
After 4 weeks, is this matter after 4 weeks?
Okay.
Item 19.
My lord, there is a application for condonation of delay of some 715 days or something.
Before your senior counsel, I want to submit that the degree has already been executed in the year 2023. I have copy of the orders for your learned senior counsel, sir. I may be allowed to bring it into the record by filing an affidavit or so lordship permit.
No,
Decree has been executed.
No, degree executed, no matter. But matter remains, my lord. Decree was illegally executed anyway. So, my lord, if I win this case, the second appeal, then I will file an application under section 144 of the.
Let her bring this on record. It will be difficult otherwise to take up that condemnation of
No,
delay.
my submission may be the degree is executed, no doubt.
Sorry?
Degree is executed.
Hmm.
But my intention is, mainly concern is, my client's concern is, if the impugned order is set aside, impugned judgment is set aside, then we can go for restitution of the land under section 144 CPCT.
Lordship, case was of concurrent finding. We have won in 2 courts. Sale deed was affirmed, our counterclaim has been decreased.
Anyway, that will come on merit, my lord.
Hearing is to be done. I may be allowed to place it on record. A date may be fixed. I will be prepared for this.
Let her place it on record. Let her
I
place
will
it
do
on
that
record
Okay.
for just decision of this case. Learned Senior Counsel Mr. R.P. Sharma, assisted by Learned Counsel Miss
A Deka.
A. Deka is present. For the appellants, Learned Counsel Miss
S. Dasgupta.
S. Dasgupta is present for the respondents and has submitted that the decree has already been executed and she has prayed for time to place the decree on record through an affidavit or IA.
Yes, I will file an
Through
affidavit.
an affidavit. Okay. Full stop. List this matter after 2 weeks.
My lord, a date may fixed because the condonation petition only.
Yes, yes. Date of the 3rd of April.
3rd of April will be problematic for me. Thereafter, after 3rd of April.
Any fifth of
After
April.
BU then,
Yes,
Okay.
because they will come and sign the affidavit. So I'll have to.
list this matter on after BU. 24th April.
Okay.
Item 23.
9. তে দুটাতে লৈ ল'ম এটা বাজা নাইতো হ'ব I'll come back whenever senior counsel is ready I'll come back you can call me
Yeah,
yes
Your Lordship, I am appealing for the respondent husband.
yes
They have challenged the restitution of conjugal rights, Your Lordship,
Yes,
which was decreed in favor of me. Prior to going to the merit of the case, Your Lordship, I have given the instruction was that an accord may be made, Your Lordship, if Your Lordship,
for settlement
or settlement, Your Lordship,
Yes,
under
yes.
Your Lordship,
for amicable settlement
Amicable.
whether restituted or not
yes, whether it's
Okay.
possible to
restart the marriage or not
Yes.
maybe not also
and Your Lordship,
only you want a settlement
yes, Your Lordship, but what is play is that Your Lordship may fix a date.
Hmm.
All the parties physically, personally, and Your Lordship in camera, Your Lordship may voluntarily go through them and assist. And
are you agreeable parties may come
yes, Your Lordship, after
I will not be taking up the civil bench from the
Your
next
Lordship may particularly if Your Lordship can take up this particular matter because if Your Lordship directs it, it will be in camera, Your Lordship. So only thing is that someone under the supervision of Your Lordship, maybe there something good.
somebody else will be there I'll just direct the parties to appear I won't fix for myself somebody else will be there I'll just ask the parties to appear as agreed by the learned but I'm not having the bench
Your Lordship, any
no I don't think so I won't be having the bench
no, Your Lordship, if Your Lordship fix a date, if Your Lordship is not taking up criminal civil matter, then Your Lordship can adjourn it or in any way one even if it is a fixed case, if Your Lordship, we see there are items in the even in the criminal bench where matters are part heard and coming in the criminal bench because that particular Your Lordship.
Criminal bench I have been taking up because these are matters relating to a single FIR.
Yes.
So they have placed these matters before me, and which I have rejected. So they had no other option but to place it because of the notification. But here, there's no such situation. So I'll just ask the parties to appear. They may appear before anybody. Learned Counsel Miss R. Chaudhary, no? S.B. Chaudhary is present for the appellants. This is an appeal, no?
Yes.
And Learned Counsel Mr.
B. Pushilal.
B. Pushilal is present on behalf of the respondents.
Sole respondent.
On behalf of the respondent, full stop. It is submitted that the parties are willing to settle their dispute amicably. The parties are directed to appear personally, and their parties will be heard in camera. This is there is an IA also.
There is a delay, Your Lordship.
It has been disposed
So
of.
delay itself, it can be the order may be passed.
Okay. IA लिखिएगा. So should I fix a date or
yes?
Is this matter on? When do you want? They interpret. So they'll appear, no? Both according to the convenience. Yes. And as soon as they appear, we will hear them.
Yes.
If both are present at the same time, we will hear them. Or the court will hear them. Before whomever this matter is placed. Ideally, in that petition, I am passing this order. The other matter is not registered, so in IA itself, I am passing this order.
Yes, we are not arguing on merits, only settlement.
Yes.
Habla.
Item 6.
Yes. Yes, that is already given, so already given. But if you want to place your submission, then I'll come up. There she is. Yes, yes. Page. Page 7, yes. You are the, yes. Mm. 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 You are the appellant. Mm. 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 Yeah. Mm. Yeah. पूरी ठीक है था. Page 13. Mm. Yes. Yes. Just a moment. What you're saying that earlier he has sold a land to this defendant one, and then he made a gift deed and transferred the land to his wife. So he cannot be the vendor now. This is what you are meaning. He cannot sell the land to plaintiff. Yes. Because he has transferred the land to his wife. Yes. That was not in the pleadings. Where did you get it? In the evidence? Whose evidence? In cross-examination. Oh, evidence. Okay, okay. Okay. Let me see plaintiff's evidence. Plaintiff's evidence. Maybe in the judgment it will be. Yes, let me see. He again returned the land to her husband, Samina Begum. Returned the land to husband by oral gift deed in page, which page? Did you mention about this in the first epic? The issue was raised. So there is a executed a memorandum of gift exhibit 7. This was not taken in pleadings also. She has prepared a memorandum of oral gift.
And I think the property.
Yes, yes.
And I can
Purchased.
then on
Yes, yes. I have two citations given by you. Yes. Yes. Beyond pleadings, there is always there. Mm. Yes. All right, I'll pass an order. Hmm. First, I'll have to RSA. So first, passing an order of injunction is not justified. First, I'll have to consider the substantial question of law. Then only then any order of status quo can be passed. Hmm. But first, I'll have to deal with this, and then I'll go to that. Otherwise, there is a judgment also by the Supreme Court that without considering the substantial question of law, no order can be passed. Yes. Hmm. We'll have to dismiss it. Let's see. At that time, I couldn't find, but now I think you have a point. Let's see. Because that day, that's only on the point that there was no evidence or there was no pleadings and evidence was led and weakness of the defendant's case. And then I was not clarified about the point. So I have taken up this argument again today. Mm. Let me see. At that time, I couldn't understand because after going through the judgment, I thought that maybe you have given your signature. Huh? No, civil bench one. Yes, yes. No, in outstations I take up. Outstations I take up. Here in no high court in outstations I take up. So this other courts outlying yes outlying benches I take up. So here I think this is for the second time I have taken up maybe. Outlying benches we have no other choice. এইটো এইখন থাকি গ'ল অথনি